Good afternoon. The Subcommittee on National Parks, Forests, and Public Lands will come to order. The subcommittee is meeting today to hear testimony on 7 public lands bills. Under Committee Rule 4F, any oral opening statements at hearings are limited to the chair and the ranking minority member or their designees, but I see that our ranking member is here. This will allow us to hear from our witnesses sooner and help members keep to their schedules. Therefore, I ask unanimous consent that all other members' opening statements be made part of the hearing record if they are submitted to the clerk by 5 p.m. today or the close of the hearing, whichever comes first. Hearing no objection, so ordered. Without objection, the chair may also declare a recess subject to the call of the chair. As described in the notice, statements, documents, or motions must be submitted to the electronic repository at hnrcdocs@mail.house.gov. Additionally, please note that as with in-person writings, members are responsible for their own microphones. As with our in-person meetings, members can be muted by staff only to avoid inadvertent background noise. Due to the broad interest in today's hearing, I would like to ask unanimous consent that all interested members be allowed to join us and participate. Finally, members or witnesses experiencing technical problems should inform committee staff immediately so we can get those resolved. And I will now give my opening statement. Thank you all for attending the Subcommittee on National Parks, Forests, and Public Lands legislative hearing on 7 public lands bills. I would like to extend my gratitude to the bill sponsors as well as to our witnesses for taking the time to be here with us today. Throughout these past few months, our nation has been in crisis, battling an unprecedented global pandemic that has thrown American lives into disarray. We're living in a new reality, one where Americans have changed their daily routines and made personal sacrifices to protect one another from the coronavirus. One where countless individuals have joined together to help vulnerable communities. Now, as our country is coming to terms with another deadly crisis, the legacy of American racism that has permeated every facet of our society, I'm hopeful that we as Americans will dedicate the same selfless courage and determination toward addressing the institutional racism that plagues our country. We're living with new constraints on how we conduct business, but this has not stopped the committee from continuing its oversight work and from elevating important perspectives. Since the start of the pandemic, the committee has held digital forums on critical issues, including the administration's decision to prematurely reopen national parks and wildfire response and preparedness during the coronavirus pandemic. Oversight remains a vital function of Congress. Today, maybe even more so than ever, but it is also Congress's job to find solutions, to consider and enact laws that help make our nation safer, more equitable, and a place that is representative of our shared humanity. The bills before the subcommittee today are an appropriate place for us to resume our legislative duties as they touch on many of the priorities for this subcommittee. Today, we'll consider proposals that promote conservation and enhanced educational opportunities by improving land management efficiencies. We will review legislation that will help bridge the digital divide between rural and urban communities, helping the nearly 30 million Americans stuck on the wrong side of the digital divide who have struggled to keep up in a world where stay-at-home orders increased everyone's reliance on the internet, reap the economic, educational, and public safety benefits that come with access to advanced broadband. We'll discuss bills that highlight the need to protect unique landscapes and stories representative of the American experience, and that address impacts of unauthorized drone incursions on wildfire suppression. And we will hear about the importance of recognizing and respecting traditional uses on our public lands. In my home state of New Mexico, acequias and land grants have long played a critical role in our way of life. For more than a century, land grant communities in the Southwest have fought for recognition and access to their historic communal lands, which are necessary to sustain the land-based heritage and agricultural economies of many New Mexico communities. I would like to commend my good friend, colleague, and mentor, Congressman Ben Ray Lujan, for his efforts to highlight the importance of land grants and acequias and to ensure enhanced access and consultation between the federal government and local stakeholders. Thank you again to the sponsoring members of Congress and witnesses here with us today. I look forward to hearing your insights and to working with all of you as we move these important proposals through the legislative process. I now recognize the ranking minority member for his opening statement. And Mr. Curtis, you have 5 minutes.
Chair Holland, I'm sitting in for Mr. Curtis today. It's Representative Westerman.
Thank you, Mr. Westerman. Welcome, and we look forward to your statement.
Yeah, we're forgetting what we look like. We've been apart for so long. Hopefully we can get back together soon. Before we get on to the subject matter at hand, it's important to address the fact that these virtual hearings are not an equal replacement for in-person debate and discourse. By now, we're all too familiar with being interrupted by reminders for everyone to please mute their microphone, with members having technical difficulties or bandwidth issues preventing them from voting, or any number of other problems that crop up virtually. And I see my good friend, Representative Huffman. I've been seeing him in the T&I committee hearings, and Mr. Lowenthal. It seems like we've got a few from T&I that have come over to Natural Resources. And just to put that in perspective, we've been doing a markup 12 hours yesterday, and we've been going since 9:30 this morning, and it looks like we may continue through the night. And a big part of that is because of the trying to do this virtually. On top of that, the very definition of Congress means coming together and meeting. And I believe we're neglecting our duties as elected representatives when we trade face-to-face discussions for computer screens. Also believe we're neglecting our duties to lead America as we come out of this pandemic. We expect a lot of people, about 2/3 of the country cannot work remotely, and we should be leading by example on how to do our jobs. I strongly encourage both you, Madam Chair, and Chairman Grijalva to both start or stop the broadcast of partisan forums and to begin scheduling either hybrid or in-person hearings and markups immediately. To quote Teddy Roosevelt, much has been given us and much will be rightfully expected from us. We have duties to others and duties to ourselves, and we can shirk neither. Across the street, the Senate is safely holding in-person hearings. They're receiving administration testimony. They just voted a landmark piece of public lands legislation. We sometimes deride the Senate for its deliberative, often sluggish behavior, yet because of committee Democrats' decisions, the Senate is now outpacing us on public lands issues. Across America, men and women in essential jobs continue working tirelessly to keep our country afloat. The very least that we, as the elected representatives of the American people, can do is show up and do our job. The American people deserve nothing less, and I urge my colleagues to get back to work. Now, we do have a number of serious legislative proposals before us today, and I'd like to highlight a few. H.R. 4257, sponsored by my colleague from Utah, Congressman Stewart, is a common sense piece of legislation that will help meet the goal of rationalizing land ownership in the West. The bill creates an additional authority for the United States to acquire state lands in federal conservation areas and to compensate the states with replacement federal lands. This bipartisan proposal expands existing authority that allows Western states to select federal lands in lieu of lands lost to the states when original statehood land grants were completed. We'll also consider H.R. 5040, the Air Safety Act, offered by the Deputy Republican leader of this subcommittee, John Curtis. The bipartisan bill requires a study on drone incursions during wildfire suppression. Although laws exist prohibiting interference with wildfire fighting, many people fly their private drones near fires to take pictures and videos. Unauthorized drones flying in these areas can cause all aerial firefighting tools, including helicopters dropping flame retardant, to be grounded, which wastes valuable time and money that could otherwise be used to suppress the fire and save lives and property. We will consider H.R. 1267, which designates the mountain ridge where an Air Force B-47 strategic bomber crashed while on a training mission in Montana in 1962. and we will designate it as the B-47 Ridge. The crash killed the 4 airmen on board. Representative Jim Forte has worked hard with the Montana delegation to get this lasting tribute to those brave souls signed into law. We will also consider H.R. 2611, the Public Lands Telecommunications Act, sponsored by Representative Huffman. This bill is intended to facilitate further expansion of broadband access in rural areas, which is certainly a laudable effort and one I support. We'll also consider H.R. 7045, offered by Representative Case of Hawaii. This bill is a first step towards the creation of Hawaii's first ever national forest. Hawaii is one of the few states without a national forest and is the only state with tropical rainforest. We'll also hear testimony on H.R. 7099, offered by Chairman Grijalva. This bill authorizes an equal value land exchange between the University of Arizona and the Forest Service. For 20 years, the University of Arizona and the Coconino National Forest operated under the false assumption that the university owned a 13.3 acre headquarters for the V-Bar-V Ranch, a university research center. After being unable to come to an agreement with the Forest Service, the University of Arizona has sought a legislative resolution to the matter. These are all substantive bills that warrant the subcommittee's attention. Unfortunately, this is the first real action this committee has taken since March. Instead of finding creative, safe ways to bring us back together, committee Democrats have instead spent their time holding partisan forums without a single Republican voice. I urge my friends on the other side of the aisle to follow the agreed upon rules of this committee and this House and allow for thoughtful debate and discourse that have been hallmarks of American representative government. I would ask that you allow that to resume. And with that, I yield back, Madam Chair.
Thank you so much, Ranking Member Westerman, and thank everyone again for being here today. Now I would like to turn to our first panel and welcome the members of Congress who wish to testify on the bills they have sponsored. Let me remind the witnesses that under our committee rules, they must limit their oral statements to 5 minutes, but their entire statement will appear in the hearing record. When you begin, the timer will start, and it will turn orange when you have 1 minute remaining and red when your time has expired. I recommend that members and witnesses joining remotely use grid view so that they may pin the timer on their screen. And if you hover, I believe it's to the top right, you will be able to click into grid view. After your testimony is complete, please remember to mute yourself to avoid any inadvertent background noise. I will also allow the entire panel to testify before questioning the witnesses. The chair now recognizes the gentleman from Utah, Mr. Curtis. Mr. Curtis, you have 5 minutes.
Thank you, Madam Chair. It's a pleasure to see you, and to all my colleagues out there. It's a delight to see you, and hope you're all well. Thank you for holding a hearing on my bill, the Aerial Incursion Repercussion Act, the Air Safety Act. The Air Safety Act is a simple bill that will have a tremendous impact on wildfire fighting. When a wildfire breaks out, the FAA sets up temporary flight restrictions, or TFRs, essentially setting up no-fly zones around the wildfire. When people fly their personal drones into these TFRs to take pictures and videos of the fire, all aerial firefighting efforts must be grounded until the drone is gone. These incursions waste valuable time and money that could otherwise be used to save lives and property. For example, in Utah in 2015, a fire in Washington County cost the state nearly $10 million because of 5 drones flying within the TFR. During the lake fire in California, 3 planes carrying flame suppressant were unable to drop their cargo on the fire, resulted in an estimated $10,000 to $15,000 cost. In 2018, during one of the worst fires in my district, all firefighting aircraft had to be grounded, as well as 3 helicopters supporting ground crews because of 1 drone. Who knows how much quicker these fires could have been contained if the firefighters were able to utilize every tool they have. The Air Safety Act directs the Forest Service and BLM to look at the drone incursions over 5 years and determine how much time and money was wasted, as well as ways to remove drones and prevent them from interfering in the first place. I'd like to enter for the record a letter of support from the Wilderness Society, a testimony in support of the Air Safety Act from the National Association of State Foresters. Given their extensive experience in firefighting, in the future, I'd like to propose an amendment to include state foresters in the study, as they will provide valuable feedback and experience. I'm hopeful the Air Safety Act Act will soon be considered by this committee at markup, and we can do just that. I'd also like to thank Mr. Huffman for spearheading this effort with me and for his commitment to bipartisanship. On that same note, I'd like to congratulate him on his Public Lands Telecommunications Act also being considered today. Earlier this Congress, I introduced the Rural Broadband Permitting Efficiency Act to streamline rural broadband permitting. Last Congress, this same committee approved my bill and Mr. Huffman's bill together by unanimous consent. I'm hopeful that my bill will also be able to be considered by this committee in the near future. Mr. Huffman, I'd like to continue to work together with you on this as we share the same goal for connecting rural America. Thank you for the chance to testify today. I yield my time.
Thank you so much, Mr. Curtis. The chair now recognizes, is Mr. Stewart here? I don't see Mr. Stewart here, so we will come back to Mr. Stewart. And let's see, the chair will now recognize the gentleman from Montana, Mr. Gianforte.
Thank you for the time today, Chairwoman Holland and Ranking Member Westerman. It's good to see everybody. And it's great to be back at Natural Resources Committee, even if it is virtually. Today, my bill, H.R. 1267, the B47 Ridge Designation Act, is before this committee. The bill would designate an unnamed mountain ridge located southwest of Immigrant Peak in Montana as B47 Ridge. This measure would honor Lieutenant Fred Hicksonbow, Captain Bill Falconer, Lieutenant Lloyd Sawyers, and Lieutenant David Sutton. On July 23, 1962, all four took off from Dyess Air Force Base for a routine training mission. Their route took them from Texas to Montana, where they flew the B-57 through Paradise Valley. Unfortunately, the bomber and crew crashed into the side of Immigrant Peak, scattering debris that can still be seen today. One resident remembered the crash and hiked up years later. Brian Wells is with us today. He hiked to the crash site many times, but decided more should be done to honor the four men that gave their lives there on Immigrant Peak. In 2016, Brian built a memorial for the crew and invited their families to come place that memorial. After working with Brian Wells on the Yellowstone Gateway Protection Act, he approached me about getting a plaque on the ridge for those crew members, and today, here we are. The companion bill, led by Senators Daines and Tester, had a productive hearing last year in the Senate, and I'm hoping for the same here today. So, Madam Chair, I appreciate the time, and with that, I yield back.
Thank you so much, Mr. Gianforte, and thank you for being here. The chair now recognizes the gentleman from California, Mr. Huffman.
Thank you, Madam Chair, for including my bill, H.R. 2611, the Public Lands Telecom Act, in today's hearing and for the opportunity to testify. Thanks also for bringing our great Humboldt County broadband champion, Connie Stewart, in to be a witness on the next panel. We're thrilled to have her. And let me just take a moment to congratulate Representative Curtis on his bill that I've partnered with him on regarding drones and fire safety. It's a great bill, and I appreciate his kind words about this broadband bill as well. Certainly, I promise to continue working closely with you, Mr. Curtis, and others in a bipartisan way on these issues. And lastly, Mr. Gianforte represents a beautiful part of the world, and I do fondly recall those of us that did a CODEL to Yellowstone had a chance to visit the sites that he spoke of. It's a really special place, and congratulations, Mr. Gianforte, on that legislation. So my Public Lands Telecom bill, I believe, takes a very innovative approach to broadband deployment by providing federal land management agencies the authority, incentives, and the resources to expand telecommunication infrastructure and services in rural communities and tribal lands. And the first point I would make is that it's modeled on proven successes of land use fees, providing fee retention authority to the Interior Department agencies like BLM, National Park Service, for rights of way and other telecom infrastructure use authorizations. This bill would ensure that those fees are reinvested to further broadband and telecommunications deployment. That means that when a company pays a land management agency, let's say for a permit to construct a cell tower or a fiber optic cable, that money stays with the agency. It would go towards activities like preparing needs assessments to designate communication sites, maybe developing management plans for communication sites on public lands, or training to manage those sites, expanding connectivity partnerships, etc. With this bill, agencies would finally have an incentive to get out of their silos and think creatively about collaborating and finding win-win broadband partnerships. The second part I would emphasize is that the bill provides cooperative agreement authority. This is a key ingredient to getting our public land managers working with private industry and local communities to expand telecommunication infrastructure and services. We've got a lot of rural communities and tribes in my district. Many of you on this committee do as well. And you know that it is time to leverage their proximity to our nation's public lands managers for investments in telecom infrastructure. We know that high-speed broadband is only becoming more essential to economic development, education, public safety, and a vibrant quality of life. But nationwide, we also know that 1/4 of rural America and about 1/3 of those on tribal lands lack quality broadband. So the longer we allow this digital divide to persist, the more Americans are left behind. And we know the pandemic has given us an even clearer understanding of this. People are staying home from work and trying to do remote learning, remote work, distance, telehealth, all sorts of things. But for any of it to work, you need a good internet connection. Our public land managers need this too. They need it for public safety, for enhanced user experiences, and for their own basic communications. And yet I have been frustrated to learn that for a variety of reasons, they simply never operate outside of their own silos. They don't even partner with sister federal agencies that might be right next door, where they could obviously go in together and have better solutions that meet multiple needs. So if we can break down these silos, I believe our federal public land managers can pursue win-win partnerships with neighboring rural communities, tribes, private sector partners, and obviously their own sister agencies. And that's what the increased authorities and the incentives and the resources in this bill do. The approach I'm proposing is straightforward. It doesn't cost the government any money. It is broadly supported by industry, rural communities, and a similar version reported out of this committee with unanimous consent in the last Congress. We may not think of this subcommittee as a place where we do telecommunications, but the truth is we have a great opportunity right here to do something big and positive for underserved rural communities on broadband. I appreciate the opportunity to testify, and again, look forward to hearing from my constituent, Connie Stewart, shortly. Thanks very much, Madam Chair. I yield back.
Thank you so much, Mr. Huffman. And okay, let's go to the chair now recognizes Mr. Case.
Chair Holland, Ranking Member Westerman, and members of our subcommittee. Aloha from Hawaii, and thank you very much for allowing me to testify today in support of HR 7045, the bill that I've introduced with my colleague, Congresswoman Gabbard, to instruct the U.S. Forest Service to conduct a study to identify parcels of land in Hawaii that could be incorporated into a national forest and help the national forest system fulfill its mission in new ways. Soon you will hear from Bob Masuda, the first deputy of the Department of Land and Natural Resources, who has been a longstanding champion of a national forest in Hawaii. And I welcome him here with you today. Our Hawaii is the most isolated island chain and one of the most ecologically diverse places in our entire world. Within our constrained border, we have 10 of the 13 world climate zones, ecosystems ranging from the deserts to the tropics, where plants and animals that found their way to Hawaii evolved like nowhere else. A 2014 survey identified 9,975 endemic species in Hawaii, many of which are relying on our fragile ecosystem to survive. However, since the onset of human arrival, especially in the last centuries, Hawaii has lost almost half of our native forest cover. Despite the threats to our unique biodiversity, Hawaii remains one of a handful of states that does not have a national forest. Invasive species have also posed a threat to our forests and biodiversity that the Forest Service can help address. The threat to our state tree, the ohia lehua, is illustrative of our growing crisis. Used for poi boards and outrigger canoes and many other uses, the ohia lehua is important to Hawaiian culture and our island watersheds. Ohia grows throughout the watershed, creating new soils, stabilizing steep mountain ridges, and comprises approximately 80% of our native forests. However, rapid ohia death, or ROD, caused by an invasive fungal pathogen, kills ohia trees quickly and threatens the stability of our native forests. Since its discovery on the Big Island in 2014, ROD has spread to Kauai, Maui, and Oahu, and has killed hundreds of thousands of trees. Despite these threats, our federal government does not have a way to adequately protect these unique tropical forest ecosystems. The National Forest Service offers a way to better manage these forests. The system currently comprises 154 national forests, 20 national grasslands, and several other federal land designations containing 193 million acres. However, it currently does not include any land in Hawaii. The National Forest Service could help Hawaii's forests simply by performing its core mission to conserve land for a variety of uses to include watershed management, research, cultural site preservation, wildlife habitat management, and research and outdoor recreation. Establishing a national forest in Hawaii would provide research, cultural, and commercial opportunities in Hawaii. It would expand upon the Hawaii Experimental Tropical Forest by providing greater support for tropical forest conservation and research throughout the Hawaiian Islands. It would provide greater public access to lands for recreational activities and cultural practices, and it would help Hawaii diversify our economy away from our reliance on tourism. My bill provides the first step in establishing a national forest in Hawaii. It would help inventory where Hawaii's native koa, ohia, and sandalwood forests can be conserved and expanded for current cultural and commercial practices. It would help identify where cultural sites could be better conserved and access expanded to the public and practitioners. It would help provide the basis to bring together local stakeholders to move forward the conversation of how to responsibly establish a national forest in Hawaii in a manner that will benefit both Hawaii's island communities and our National Forest Service. I want to thank you again for the opportunity to speak on behalf of our bill. I'm hopeful that this measure will begin the process of establishing the long overdue first national forest in Hawaii and adequately conserving some of the most unique and precious forest resources in our world. Mahalo, and I yield back.
Thank you, Mr. Case. The chair now recognizes the gentleman from Utah, Mr. Stewart. Mr. Stewart, will you unmute yourself, please? Thank you.
Oh my gosh, how many times have we seen people do that, right? We should all have to put $1 in the mute jar. Thank you, Madam Chair and the ranking member, other members. We wish we could be together, obviously, and look forward to more of a business as usual, but we're grateful you gave us the opportunity to talk about these bills that are important to us, even if we couldn't do it in person. I want you to know the ACE bill, I think, is something that we would hope that everyone could support. It truly is a bipartisan effort. A wide coalition of groups have been supportive of this, and I'll just speak about it very, very briefly if I could. It would make the law a common sense notion that getting state trust lands out of federal conservation lands is good for the public, and it's actually even better for the federal government management. And the basics of it are this: states with state trust land parcels may trade state parcels within an eligible federal conservation area, for example, parks and monuments and other conservation areas, for unappropriated public lands of equal value. And I want to emphasize that trades will be of equal value with the expedited valuation of low-valued lands. The trades are subject to NEPA. The Secretary would have the discretion to protect against transactions that are not in the public interest, and valid existing rights, such as mining claims or grazing leases, are protected. And just a little bit of background on this, a little Utah trivia, if you would. Utah has granted 4 sections per township. So 4 out of every 36 or 1 mile by 1 mile squares. And the state has a fiduciary duty, a responsibility to manage these trust lands for the benefits of everyone that has been set aside in Utah Constitution. But mostly it goes to education and a portion of it, although quite a bit smaller, to hospitals. And after the 96 proclamation of the Grand Staircase, which I know everyone on this committee is familiar with, it took the act of Congress to remove these trapped state trust land sections. Almost all of the Western states have granted trust lands in a statehood to be managed for the benefit of education and other public interests, as I've described here. But the creation of the federal conservation areas, such as national monuments, which has an enormous impact on my district. In some of my counties, 93% of the county is controlled by the federal government and generally in national parks. Examples of that have made such trust lands unmanageable, as you can imagine, being trapped inside some of these large tracts of federal land. Currently, administrative exchanges are complicated, and as we all know, they take years, in some cases even decades, and they span various administrations. The congressional process is very unpredictable, and it's just very slow. The ACE Act creates a process for states to relinquish state trust lands with federal conservation areas and select replacement federal land. The trade improves management of the federal conservation areas by allowing unified management over areas that are designated for conservation management. And that just makes sense. If we have these large tracts of federally managed and federally mandated lands with little parcels of state trust lands inside them, it's to the benefit of the federal government and to all those who want to conserve and protect these in order to exchange those pieces out. It also codifies the right of states to relinquish state trust lands within the federal designated areas of the United States and to replace those selected lands with other lands that could be managed to the well-being of the constituents, again, primarily education and hospitals in the state. There's very little controversy around this, broad support, bipartisan support, and we encourage and I would ask for the committee's consideration. So, Madam Chair, thank you for the few minutes that I've been able to take, and to others for being with us today. I yield back.
Thank you so much, Mr. Stewart. And I'll ask unanimous consent for our colleague Ben Ray Lujan to testify on his bill. Without objection, the chair recognizes Mr. Lujan from New Mexico for 5 minutes.
Chairwoman Holland, Ranking Member Westerman, thank you so much for holding this important hearing and for allowing me, a member of Congress who's not on the committee, to be able to testify today. But many pieces of legislation that I certainly hope will earn bipartisan support and that will soon pass out of the subcommittee, pass out of the committee, make their way to the floor and see how we can all work together to get these passed in the U.S. Senate and sent to the president for signature. So I look forward to working with my colleagues on a bipartisan basis to get these bills across the finish line. One of the bills that is before the committee today is an important piece of legislation to better address the challenges faced by land grant communities and acequia communities. And all of those family members, ranchers, farmers that could not survive without access to these important lands and acequias. I'm actually sitting on one here today. So because I'm able to be here in New Mexico to share with each of my colleagues, you see one of those acequias flowing right behind me. It's an acequia that comes from the watersheds as the snow accumulates in New Mexico and goes to our rivers or local watersheds that moves into farming communities. And every year we take our shovels out and we carve these out by hand to clean them up. And that's one of the most important aspects of these lands, to be able to keep our small farmers be able to get access to these important water resources in New Mexico. I also want to recognize my friend Arturo Archuleta, who's with the New Mexico Land Grant Council, for testifying today. And it's great to be with you today, Arturo. Madam Chair, and to the committee, I thank you for allowing Arturo to testify. The Land Grant and Acequia Traditional Use Recognition Act, which I introduced with my colleagues from New Mexico, Congressman Holland and Xochitl Torres Small, ensures greater consultation between the federal government and New Mexico's land grants and acequias. My bill also creates a process to allow New Mexico's land grants to establish their historical boundaries and provides them with pathways for acquiring that land when the federal government disposes of it. I grew up in the small community of Nambe. I'm fourth generation on this little farm that I'm speaking to you from today. My family is a member of the Hakuna Land Grant. So this has been a part of my family experience for generations, and it's ingrained in me the importance of taking care of our land and our water. The legislation will make it easier for land grant Mercedes to work with federal land management agencies, such as the Forest Service, and it requires federal agencies to make land grant Mercedes aware of changes to management plans and encourages agencies to mitigate any adverse impacts due to federal action. This bill instructs the federal government to issue guidance on permitting and permissible uses of these lands to the land grant Mercedes. That way, if a permit is required, communities will know exactly what they need to do and when they need to do it right out of the gate. This legislation also ensures that federal government appropriately recognizes spiritual and cultural sites while providing greater tools for land grants to acquire the lands that these sites reside on. This legislation also helps New Mexican families who have stewarded these lands for generations maintain precious infrastructure such as the acequias. Acequias are crucial water infrastructure for traditional communities, which is why this legislation codifies a previous legal ruling that determined consultation and special use permits are not required for maintenance and improvements within the historic easement for acequias. And with that, Madam Chair, I want to say thank you to the committee. I look forward to the questions. And at the appropriate time, I do have testimony to submit into the record. Thank you to the committee, and I yield back.
Thank you. Thank you so much, Mr. Lujan. The chair now recognizes our esteemed chair of the full committee, Mr. Grijalva from Arizona.
Thank you so much, Chair Holland, and thank you for holding the hearing today and the array of bipartisan pieces of important legislation that you have called up. Thank you for that. And it's important that the House continue to work during these unprecedented times, and I appreciate your effort and the effort of your staff to continue that work. Good pieces of legislation, some overdue. Mr. Hoffman and Mr. Cases, and I appreciate those being on the agenda. We are here in Southern Arizona. We're struggling with the Bighorn fire, and one of the areas in which there has been problems has been with private drones slowing down the process of fire suppression. And I want to thank Mr. Curtis for his legislation. And the hearing today, I'm happy we can conduct it safely and smartly while conducting this very important business. And I appreciate that, Madam Chair. Representative Halloran and I introduced HR 7099 after months of work and consultation with our colleagues in the House and the Senate and with senior staff from the University of Arizona. This bill simply would authorize an important land exchange between the university and the Forest Service on 2 small parcels of Coconino Forest National Forest. Once exchanged, the university can develop facilities for a site including dorms and classrooms to support the newly accredited College of Veterinary Medicine. These new accommodations will allow students that go through the program to receive hands-on in the field experience as a foundation and a foundational part of their curriculum. The bill is straightforward, as it is important to the university and to the state of Arizona. It supports the next generation of veterinarians, and the language we have included ensures that there will be a fair return on the exchange for the taxpayer. The Senate companion receives the bipartisan support of our 2 senators, and I hope my bill will find the same broad support in the House. Madam Chair, thank you again. This is a good complement to the University of Arizona's Campus Agricultural Center. It complements that effort, and with a new veterinary school that's been accredited, so few in the country, and such a demand for this curriculum and veterinarians, it is an opportunity. It's a fair exchange, equal value, and thank you, Madam Chair, and I yield back.
Madam Chair, this is Gosar.
Yes, Mr. Gosar.
Yes, since there's nobody on the second panel for this, may I address the witness in regards to in support?
I believe there are some people on for the second panel, Mr. Gosar. Would you mind if we let the second panel give their testimony, and then we'll open it up for questions for everyone? Is that okay with you?
Well, it's more towards the legislative text that the chairman has introduced.
I believe we should go with the second panel, and then I will recognize you for questions, and you will absolutely be able to get your question on the record.
Well, it's not to the witnesses other than the chairman.
Yes, and the chairman should be here for questions when you are ready. But I would like to stay with our agenda, which is to thank the sponsoring members of Congress for their valuable testimony and transition to the next panel. And you will absolutely have an opportunity to ask questions, Mr. Gosar.
I'm not.
Thank you so much. So I do thank the sponsoring members of Congress for their valuable testimony. Now we will transition to our second panel. As with the first panel, oral statements are limited to 5 minutes, but your entire statement will be made part of the hearing record. When you begin, the timer will start and it will turn orange when you have 1 minute remaining and red when your time is expired. After the witness has testified, members will be given the opportunity to ask questions. The chair now recognizes Mr. Ryan Bruner, President of the National Association of State Trust Lands. Mr. Bruner, you have 5 minutes.
Well, thank you, Chairwoman Holland, Ranking Member Young, and members of the subcommittee, along with Representative Stewart. My name is Ryan Bruner, and I'm the South Dakota Commissioner of School and Public Lands and the President of the National Association of State Trust Lands, which is formerly known as the Western States Land Commissioners Association. I thank the subcommittee for conducting the hearing today on this critical issue of how to resolve the land tenure issues between state school and institutional trust lands and federal land ownership. I'm here to ask for your support of H.R. 244, the Advancing Conservation and Education Act, or ACE legislation. The National Association of State Trust Lands is comprised of 20 Western and some not so Western states who share the common mandate of managing state trust lands on behalf of the school children in our states on a bipartisan basis. Upon statehood, our member states were entrusted with hundreds of millions of acres of land and minerals to be managed specifically to provide funding for public education and other state institutions. Today, our member states manage over 515 million acres of land, submerged land, and minerals. And as a group, we are the second largest group of land managers in the nation, second only to the federal government. H.R. 244 addresses a very specific challenge with land ownership. We have a saying in the West that good fences make good neighbors. However, a large amount of our lands and minerals that our member states manage are interspersed or checkerboarded with federal lands. We are challenged with how to be good neighbors on lands that have no fences, sometimes no access, or water for livestock. When the West was settled, there was no GIS technology, no Google Earth, and no way to select lands that would fit in the changing policy prescriptions 100 years later. Instead, they were selected by legal land description with sections set aside in every township, leading to the checkerboard pattern we have today. These scattered sections are intertwined with federal lands where land management mandates vary drastically from the mandates placed upon states. Pursuant to our Statehood Enabling Act and constitutional mandates, our states are obligated to manage our lands with a single purpose, to generate revenue for public education and state institutions. This creates a new challenge in how do we be a good neighbor on lands when the federal government has mandated and the states have agreed that we manage our lands to make money for education while mandating the adjoining parcel be used or mandated for conservation. These conflicting mandates on adjoining parcels with no fencing make it hard to be a good neighbor with the federal government. Federal actions and policy decisions have trapped these school lands within national parks, wilderness areas, wildlife refuges, and national monuments. In order to keep the promise to our school children, we must craft effective tools to move these trapped state trust lands to where the generation of income is appropriate and acceptable. Existing administrative and legislative solutions are costly, complicated, time-consuming, and simply do not work. We must fix this issue. We have been working with our member states, Congress, and outside groups to craft this legislation. It will enhance federal conservation and management areas by eliminating state-owned inholdings. It has a broad spectrum of support from our states, the Western Governors Association, and conservation organizations. And Congress has held several hearings on this proposal. HR 244 is similar to existing federal statutes that permit state in lieu selections of federal public lands. These statutes allow Western states to select federal lands in lieu of lands originally granted when those lands were not available due to pre-existing conveyances. For example, if the federal government issued a homestead patent before statehood, the state was entitled to select an equal amount of available federal land in lieu of or as indemnity to the federal lands that were not available. This mechanism of relinquishment and selection has been utilized previously by Congress and is an activity of the Bureau of Land Management. Under HR 244, a state may relinquish all right and interest to the state parcels trapped within an eligible area and select replacement land utilizing this existing process. HR 244 guarantees that these transactions will be of equal value and provides for National Environmental Policy Act or NEPA compliance. In conclusion, it is important to note that HR 244 is not a proposal for disposing of federal public lands, but rather a mechanism for the United States to acquire state trust lands with high conservation values while compensating the states for the selection of replacement lands. HR 244 promotes conservation while benefiting state school children. We thank the subcommittee for your attention to this important matter and request swift action on HR 244 so that the federal government and our member states can work together to be good neighbors while promoting conservation and funding education. Thank you for the opportunity to testify, and I would be happy to answer any questions.
Thank you, Mr. Bruner. The chair now recognizes Mr. Brian Wells, Chairman of the B47 Memorial Committee.
Thank you, Chairwoman Holland and members of the House Subcommittee on National Parks, Forest and Public Lands for inviting me to speak today in support of the B47 Ridge Designation Act. My name is Brian Wells and I am the chairman of the B47 Memorial Committee and owner of Immigrant Creek Cabins located at the base of Immigrant Peak in Paradise Valley, Montana. On the evening of July 23rd, 1962, while on a routine flight from Dyess Air Force Base near Abilene, Texas, 4 U.S. Air Force crew members lost their lives after their B-47E Strategic Air Command bomber crashed at 8,500 feet into Immigrant Peak in Paradise Valley, Montana. Strategic Air Command patrol bombers were a common sight in our Montana skies during the Cold War era. The Strategic Air Command was formed in 1946 to maintain a global nuclear deterrent force. These 4 fine young men, Captain Joseph Falconer, Lieutenant Lloyd Sawyers, Lieutenant David Sutton, and Lieutenant Frederick Hicksonbaugh, and their families paid a huge price for our country. Collectively, these airmen left behind 5 young children, 4 wives, and many other family members. I have met with the members of each family, and they are wonderful people. They all support the B47 Ridge Designation Act. Their loved ones are interred on the side of this mountain. This is hallowed ground for them. Some of the family members have told me that they knew their loved ones' remains didn't make it home and they were burying empty caskets. The B47 Ridge Designation Act is not only important to these families, it is also important to our community. This tragic event had quite an impact on our community back in 1962. Many folks, including my wife, heard the explosion and saw the fireball on the side of Immigrant Peak. Our local Forest Service went to the site to fight fire. Local ranchers packed in supplies with horses to help in the search and recovery mission. Our local telephone man laid 4 miles of line to the search and recovery base camp. Malmstrom Air Force Base from Great Falls, Montana came to lead the recovery mission. This tragic event is part of our local history. This community wholeheartedly supports this legislation. Our veterans groups, county commissioners, state legislators, churches, sheriff's department, local and national environmental groups, U.S. senators, and U.S. representative. The B-47 Ridge designation passed out of the Senate with co-sponsors from our entire Montana delegation. This bill has bipartisan support. The B-47 crash site is at 8,500 feet. The site is not in a wilderness area. The debris field is spread over a mile. There is a sign at the crash site designating it a heritage site. This may be one of the most complete B-47 debris fields in existence because of its remoteness. The B-47 Ridge Designation Act is not unprecedented. There are other military memorials on public land around our state. One example is Bomber Mountain on the Montana-Wyoming border. There are also several memorials on public lands that honor wildland firefighters that have perished protecting the lands that we love. We feel the B-47 Ridge Designation Act does two things. It honors the ultimate sacrifice of these young men and their families, and it is a public service for future generations. When hikers stumble onto this debris field in the future, there will be a marker explaining what happened here and the names of the 4 young men who perished protecting our country, a reminder of the enormous sacrifice these brave men have made for all of us. So on behalf of the families and my community, I say thank you for considering this. I yield back.
Thank you, Mr. Wells. Thank you for your testimony. The chair now recognizes Ms. Connie Stewart, Executive Director of the California Center for Rural Policy.
Thank you so much, Madam Chair and members of the subcommittee, for allowing me to speak today. I'm Connie Stewart, and I am the Executive Director of the California Center for Rural Policy at Humboldt State University. And I'm here to urge you to support Congressman Huffman's H.R. 2611, the Public Lands Telecommunication Act. And I would like to thank the Congress member for introducing this important legislation. COVID has shown us the importance of universal broadband and just how many communities are still in need. So why are so many communities still without broadband? Well, today let me focus on 3 problems. The lack of reliable backhaul, especially in areas with lots of federal lands. The process and cost of federal permitting, especially if there are multiple federal land management agencies in the region, and the difficulty collaborating with federal agencies to purchase local broadband services to improve connectivity opportunities for visitors of our federal and parks and forests. H.R. 2611 is an important step in solving all 3 of these problems and enhancing service in rural communities across the country. In 2007, California created an Advanced Services Fund administered by our Public Utilities Commission to provide grants to bridge the digital divide in unserved and underserved areas. And in 2009, our region created a plan to build a fiber middle mile backbone system that could offer reliable service to any of our 100 communities. The reason we have focused on building a fiber middle mile is to create a telecommunication infrastructure foundation with the capacity to effectively adapt to future needs and to promote economic development in rural communities. I had the honor of testifying before this committee on this bill last congressional session, and let me just share a new story with the committee to illustrate the importance of H.R. 2611. In 2013, the Karuk and Yurok tribes received a grant from the state's Advanced Services Fund to provide broadband to some of the largest unserved tribal communities in the state of California. They have spent 7 years working on permitting and environmental studies. And just to be clear, this is not an issue of bad people or bad agencies, and I'm not here to object to environmental review. It's just that the current process to review broadband deployment is extremely inefficient. Every time one agency asks for a project change, another agency may have new issues with their part of the review. In addition, none of the agencies has the funding for such complex projects. How could things take 7 years? Well, here's just a few reasons. It took 1 year to get an agency to grant the tribes a permit to begin the cultural study. It took 2 years to get another agency to assign staff to engage in the NEPA process. Some federal agencies can engage in NEPA processes and issue permits at a regional level. However, other federal agencies need approval from their Washington, D.C. office. The cost of the project rose significantly due to requested proposed changes during the NEPA process, which required the tribe to delay to seek additional funding, which they've gotten, good news. And most of the staff of these agencies have never permitted a major fiber build, and so they're leaning on the side of extreme caution. And over the years, the staff has changed. The tribe has resorted to having annual meetings with all the federal partners just to keep the project moving forward. The tribe has budgeted nearly $2 million of its $25 million project to complete permits. And I'm sure HR 2611 would have made a difference in the time and cost of this project. HR 2611 has provisions providing fee retention authority to the Interior Department land management agencies to ensure funds are invested in further broadband and telecommunication deployment. I want to thank you for giving me this opportunity to testify today, Madam Chair. And with your permission, I'm submitting my entire statement for the record, and I'm happy to answer any questions. Thank you.
Thank you so much, Ms. Stewart. The chair now recognizes Mr. Arturo Archuleta, Program Manager of the New Mexico Land Grant Council and University of New Mexico Land Grant Studies. Welcome to our hearing, Mr. Archuleta. You have 5 minutes.
Buenas tardes de Dios. Good afternoon, Madam Chair, Ranking Member Westerman, and members of the committee. Thank you for the opportunity to provide testimony today. My name is Arturo Archuleta, and I am here on behalf of the New Mexico Land Grant Council, the New Mexico Land Grant Merced Consejo, numerous land grant Merced communities, and our countless ancestors who for over the past 175 years have sought justice for our communities. Our communities were established between 1689 and 1854 by grants of land from the Spanish Crown and the Mexican government in what is now the United States Southwest. Our communities were settled and populated by our Mestizo and Genízaro ancestors. When established, our communities included common lands that provided the natural resources needed for our survival. These common lands were never intended to be privatized nor alienated from the community's common ownership and use. Under the Treaty of Guadalupe Hidalgo, which ended the Mexican-American War, our property rights were to be protected and recognized by the United States federal government. Our property claims in New Mexico were adjudicated over a period that lasted more than 50 years. The process was faulty, inefficient, inequitable, and in some cases fraudulent and corrupt, oftentimes with U.S. federal government officials directly involved in the corruption. The end result of this unjust process was that millions of acres of common lands were stripped from the ownership of our local communities. Much of these former common lands are now managed by federal agencies like the U.S. Forest Service and the Bureau of Land Management. The Land Grant and Acequia Traditional Use Recognition and Consultation Act is a product of over 10 years of work between our communities, Congressman Lujan, and the entire New Mexico congressional delegation. It will provide for the recognition of longstanding traditional uses practiced by our land grant communities and acequias on federally managed lands. Acequias are centuries-old community irrigation systems, many of which have their point of water diversion and miles of water delivery infrastructure on and across federal managed lands. Under state law, both the Land Grant Mercedes and acequias are local government entities capable of entering into official consultation with the federal government. As traditional land-based communities, we have longstanding practices and customs that are reliant on the use of natural resources that surround us. These uses are ingrained in the cultural fabric of our communities. Like our Native American cousins, accessing and protecting our traditional uses and the associated natural resources plays a critical role in ensuring the cultural integrity of our communities. The need for recognition and protection of our traditional uses on federal lands is critical for preserving our communities into the future. In the past, our communities have seen the access to traditional use needs ignored or taken away completely by federal agencies in favor of other uses that they deem to be more desirable, such as commercial resource extraction or recreation. Our communities are not opposed to the multi-use mission of federal lands. In fact, we believe that our traditional uses are compatible with most other uses found on public lands and national forests today. Being consulted and involved in the management of natural resources surrounding our communities is vital to the overall health and socioeconomic well-being of our people. We rely on the forested uplands to provide sufficient water for drinking, irrigating crops, and watering livestock. We rely on vegetation products like wild herbs and pinon nuts for cultural practices and medicinal purposes. Our communities have a continuous annual need to access fuel wood to heat our homes in the fall, winter, and early spring. During economically challenging times like those that we face today, firewood is a basic survival necessity, as many of our families cannot afford the high cost of propane and natural gas. Additionally, our communities continue to suffer from the loss of communal grazing opportunities on lands now managed by the federal government. Where in the past, livestock grazing of communal pastures provided a guaranteed protein source for our families, today these closed allotments mainly offer aesthetics for an occasional hiker. In reality, both uses are completely compatible. Over the years, our communities have been placed at odds with federal land management agencies, not by our own choice, but as a direct result of having our traditional use needs ignored, partly because we are not always at the table when land management decisions are being made. The recognition and consultation aspects of this bill are important first steps in addressing and rectifying historical injustices that have crippled our communities for over a century. For decades, our communities have suffered social injustice and economic hardships as a direct result of being denied meaningful access to our traditional uses on our former common lands. The passage of H.R. 3682 would help ensure that federal land management policies and practices, regardless of changes in the administration, will honor, respect, protect, and conserve our traditional uses now and for future generations. And with that, Madam Chair, I'll yield back.
Thank you so much, Mr. Archuleta. The chair now recognizes Mr. Robert K. Masuda, First Deputy at the State of Hawaii's Department of Land and Natural Resources. Mr. Masuda, you have 5 minutes. Is Mr. Masuda?
Yes.
Okay.
Madam Chair and members of the committee, thank you for this opportunity to testify today in support of H.R. 7045, a bill to study lands that could be included in a new national forest in Hawaii. I am Bob Masuda, First Deputy Director of the Hawaii Department of Land and Natural Resources. We support enactment of H.R. 7045. We feel the study will provide valuable information and insight into land conservation options in Hawaii. I ask that my entire testimony be submitted for the record. For brevity, I would like to summarize my presentation. Hawaii is one of only 8 states without a national forest or national grasslands. Therefore, Hawaii offers an opportunity to expand the scope of the national forest system to include the unique ecosystems of the tropical Pacific. The citizens of Hawaii share a passion for the lands and resources that have sustained our islands for generations. It's ingrained into our culture and outlook. Like other island people around the world, we understand we live with finite resources on a limited land base. Living on isolated islands, we are particularly sensitive to the threats posed by pollution, climate change, and invasive species. We know that the conservation of our terrestrial and marine resources is necessary for the quality of life we now enjoy and for future generations. We believe Hawaii's existing forest reserves, watershed, and endangered species protection programs would align well with the national forests in Hawaii. The state and the U.S. Forest Service already have a successful record of ongoing collaboration in tropical forestry research. In 1992, Congress passed the Hawaii Tropical Forest Recovery Act to further research in tropical ecosystems and to designate lands for research purposes. In 1994, the state and the Forest Service completed an action plan that identified Hawaii's unique ecological resources, conservation opportunities, and areas for cooperative research. In 2007, 2 experimental tropical forests for wetland forests and dryland forests, comprising over 51,000 acres, were established on state-owned land on the Big Island. World-class forest research is being conducted on those areas by the Forest Service Institute of Pacific Islands Forestry located in Hilo. National forest management of appropriate lands could meet some of the objectives identified in the 1994 action plan, such as combating invasive species and animals, restoration of lands adversely affected by logging, overgrazing, and intensive agriculture, reestablishment of sustainable forestry, such as coal production, and watershed protection. HR 7045 is a modest proposal. It only authorizes a study. It will not establish any new national forest. It will not acquire any land, and its potential is largely aspirational. Yet, the study can identify resource protection opportunities and better educate landowners and the public about options for managing our unique island resources. We in Hawaii would welcome this opportunity to work with the Forest Service. In closing, as you consider the future of land conservation in Hawaii, allow me to share with you the motto of our state, which seems particularly apt to these proceedings. And it reads, Ua mau ke ea o ka aina I ka pono, which translates from Hawaiian into English as the life of the land is perpetuated in righteousness. Also in closing, I would like to thank Congressman Case, whose family for many, many generations have been champions and advocates for our natural and cultural resources. Thank you, Congressman Case, and thank all of you for allowing me this opportunity for natural resource and cultural protection.
Thank you. Thank you so much, Mr. Masuda. Thank you all for your valuable testimony. Reminding members that Committee Rule 3D imposes a 5-minute limit on questions. The chair will now recognize members for any questions they may wish to ask the witnesses. And I will first recognize Mr. Huffman for 5 minutes. Is Mr. Huffman still here? Yes, there we are.
Madam Chair, I will pass at this time. Thank you.
Okay, thank you. Then the chair will recognize Mr. Case for 5 minutes.
Thank you, Madam Chair. My questions to Mr. Masuda were answered by his testimony, and I would simply endorse his very strong description of the need for a national forest in Hawaii and the opportunity to incredibly diversify our national forest by the addition of the only tropical rainforests in any of the states in our country. And also recognizing his comments that this has been a long time in the making. This is a generation now that we have taken a look at how to protect our national forest, our forests here in Hawaii. And during that generation, we've seen significant degradation. So I would simply endorse his testimony and again ask for the subcommittee's support. Thank you.
Thank you very much, Mr. Case. The chair recognizes Mr. McClintock for 5 minutes.
Well, thank you, Madam Chairman. I think I can say without fear of contradiction that there is not much that Mr. Huffman and I can agree on. But HR 2611 should have become law when we passed the same bill out of the Natural Resources Committee in the 115th Congress. And I hope it will actually finish that work in the 116th. It makes perfect sense to devote the revenues generated by communications use authorizations to underwrite rural broadband, and I strongly support the bill. I do want to underscore the point made by Ms. Stewart that the principal impediment to rural broadband is the enormous cost and delay imposed by the National Environmental Policy Act. The small and dispersed populations in our rural communities are formidable economical obstacles by themselves, and the added costs imposed by NEPA combine to deny our rural communities the same broadband services enjoyed by other communities. This problem has to be addressed both by generating revenues, which this bill does, but also by reducing unnecessary costs, which this bill doesn't. HR 2611 addresses half the problem with sound fiscal policy. But we've got to address the other side of the equation as well. And Ms. Stewart, I'd like to ask you just to give us an overview of what that other side of the equation should look like. How do we bring down the cost of rural broadband?
Thank you. As I said earlier, you know, one of the issues that is addressed by this bill, it's not just a money situation here. Getting the agencies together to collaborate so that their coordinating review is going to delay review, or delay the problems that we've been seeing with review right now. And so I do believe, like, if the agencies can get together and agree on a process, and appoint one agency as the lead of that process, maybe an agency that has funding that's provided because of the ability to do fee retention, to lead the review and assure that everybody's working in a coordinated fashion. I believe that we can get these broadband projects deployed a lot faster. And so that's the real goal right now. If you have some agencies who aren't participating because they don't have the funding or the resources to appoint a person, what we're seeing is that they come in later and then they kick the review back to the starting point. And so that's what we're trying to avoid by getting them all together.
Great. Well, if you want to put that in writing, I would be happy to sit down and chat with you about how we can address that in law as well. And maybe with hope against hope, we can get Ms. Tuffin to join us on that eventually as well and complete both sides of that equation and get rid of broadband throughout our rural communities.
Thank you so much.
I will back.
Thank you, Mr. McClintock. The chair now recognizes Mr. Neguse. Is Mr. Neguse here?
Thank you, Madam Chair, and I'd pass it this time.
Thank you, Mr. Neguse. The chair now recognizes Ms. DeGette for 5 minutes.
Thank you, Madam Chair. I just wanted to make a couple of comments. Mr. Westerman, in his opening statements, referred to the passage of the bill in the Senate to reauthorize the Land and Water Conservation Fund, which I'm very, very supportive of, and I'm pleased that we are doing that. The LWCF has been around since 1965 to provide funds to federal, state, and local governments for land and water and easement on land and water. And it's something that's been around for over 60 years. It's been, or over 50 years, and it's been wildly successful. I do take a little bit of umbrage with one thing that Mr. Westerman said, though, which was that the House hasn't passed any public lands bills this big because, of course, earlier this year we passed a massive wilderness bill sponsored by with including areas in Mr. Huffman's district in Colorado and a number of other areas. We also passed last year the CORE Act, which is sponsored by Mr. Neguse, who's on this subcommittee. And in all, we've passed about over 1.3 million acres of new public lands protection in addition to the LWCF. So I would suggest the House has been really holding up its end of the bargain. And we should be very proud of the House, and we should also demand that the Senate, before the end of the year, pass the big Wilderness Act that we passed and the CORE Act and the other bills that we're talking about today that would protect more federal lands. And with that, Madam Chair, I'll yield back.
Thank you, Ms. DeGette. The chair now recognizes Mr. Westerman for 5 minutes.
Thank you, Madam Chair. And just to address the previous comments, my statements were that we haven't done anything in the House since March, whereas since March, the Senate is outpacing what we're doing in the House. Historically, the House way outpaces the Senate, but right now they're light years ahead of us in the work that they're getting.
If the gentleman would yield, thank you for clarifying. And you're right. You know, out here in Colorado, we call the Senate either the place good bills go to die or else the cave of the winds. So you have my complete support in criticizing the Senate any day of the week, and I yield back.
I think they say if you're Republican, Democrats are your opponent, and the Senate's your enemy if you're a House member. But again,
Amen.
The Senate is is far outpacing the work that we're doing in the House right now. So that should tell you something. I do have some questions for starting with Mr. Bruner. In your testimony, you stated that administrative land exchanges with agencies within the Department of Interior or with the Forest Service are no longer feasible tool to complete exchanges between states and the federal government. I've experienced that firsthand. We actually passed a bill out of this committee. It's been signed into law since December of 2018 to do a simple land exchange, 4 acres of Forest Service land for 6.3 acres of private land that was owned by a church that has tombstones in the church cemetery that have dates older than the Forest Service itself. It's been 18 months and they still haven't got the land exchange done, even with it being an act of Congress, signed into law by the president. Can you elaborate on why this is the case and how you believe the ACE Act will help make these exchanges more efficient?
Yes, certainly. Thank you very much for the question. I really appreciate it. And you give a fantastic example of how federal land exchanges can be cumbersome. Some of our member states have shared with me that doing an administrative land exchange, and Representative Stewart mentioned this at the beginning as well, can take a decade. They can take 10 years or longer to complete. And so really what we're trying to do with the ACE Act is to give us another tool that allows us to get outside of some of the administrative hurdles of the Federal Land Management Policy Act. And so there are some administrative hurdles in there that can cause this process to drag on for a long period of time. And we think that's reasonable and necessary when we're talking about state federal land exchanges that are really in the public interest. Both the state and federal government share the same public. And we think it's a pretty straightforward statement, and this has had bipartisan support, that getting in holdings that are state-owned, lands that are supposed to be generating money for public schools and transferring those to the federal government and acquiring land elsewhere that is more appropriate for the income of generation of income for our school children is in the public interest. And this gives us a tool to do that while protecting equal value, protecting NEPA compliance, leaving some more discretion up to the Secretary of Interior as far as the public interest component, and really focusing on that aspect. And so this legislation does give the Secretary of Interior 3 years. And so your example of 18 months would still be within that 3-year window, but we can go with a 3-year timeline that's more predictable. It's better for states and the federal government when working together. We can deal with the 3-year timeline. It's dealing with something that could be decades. If it gets completed at all, that gets to be very challenging. So I certainly appreciate the question.
Yeah, the 18 months doesn't count the nearly 3 decades prior to that the church tried to do the land exchange with the Forest Service before we got an act of Congress passed. Ms. Stewart, I just want to thank you for your testimony. I found it had a lot of valuable insights. I was particularly amused by the observation you shared from the president of the company that said the permit process, although not contested by even one intervener, took 24 months to complete, while the construction took only 17 months. Said therein lies some empirical proof that the permitting bureaucracy is more difficult to penetrate than granite, which I think is a good synopsis of what permitting and overregulation is like now. And I could go on about that. I used too much of my time at the start talking about the Senate, so I'm going to have to yield back. And again, thank you to all the witnesses for the testimony today.
Thank you, Mr. Westerman. The chair recognizes Mr. Gallego for 5 minutes. Mr. Gallego? Mr. Gallego?
Thank you, Ms. Chairman. I pass.
Thank you, Mr. Gallego. The chair will recognize Mr. Lowenthal for 5 minutes.
Thank you, Madam Chair, and thank all my colleagues. I find this a fascinating hearing, and I also want to thank all the witnesses. And I am very supportive of what we're trying to do here. But let me start with clarify some things. And I want to start first with Mr. Masuda. I want to thank you too, specifically for being here with us and your testimony. I think you stated that Hawaii's state forest reserves and ongoing watershed, and talked about, and also the endangered species protection programs, with how they would align perfectly with the establishment of a national forest in Hawaii. Based on your experience at the Department of Land and Natural Resources, can you briefly speak to some of the research that's being conducted at Hawaii's 2 experimental forests, and how Representative Case's proposal would help further that mission of what's going on?
Sure, I'm happy to. Our State Department of Land and Natural Resources are mainly a land management and restoration, preservation, conservation organization. We don't have the capacity for science research that the U.S. Forest Service's Institute for Pacific Islands Forestry has. The Pacific Islands, the Institute for Pacific Islands Forestry, located on the University of Hawaii Hilo campus on the Big Island, has been our go-to place for cooperative science research. Entomologists, hydrologists, all of those kinds of solid science folks and our staff work together in, for example, in our watershed protection. Congressman Case referred to Ohia Lehua and the current scourge that we have decimating 80% of our native forests, which is our watershed, is comprised of Ohia Lehua trees. Ohia Lehua is being decimated by a particular rust. We have a major group of people, including the Forest Service research folks, along with the Agricultural Research Center folks who have pathologists, which we don't have, working together in helping to control this, because Ohia Lehua protects our watershed. As I'm often reminding our friends, our boards of water supply transmit water. They transmit water. They don't provide water. It's our forests in partnership with our atmosphere that helps provide the water that fills our aquifers. Without our forests and healthy forests, it's not going to happen. And we would be subject to some pretty serious things, being an island. And working with with not having a national forest, we are limited to where our U.S. Forest Service folks can do their research over extended time. So back in 2007, we worked together with the Forest Service in using on a cooperative agreement. So the Forest Service is using state land for conducting research for a number of universities. Some of the top universities in the country have research being conducted in our wetland forests and our dryland forests. We have 2 distinct types of forests on island systems. And this research would be potentially expanded in such a way that the U.S. Forest Service's research capability, through working with the National Forest System, because the R&D sector does not have national forests. They don't manage national forests. And so we need a national forest so that we can have a federal forest system in which our research scientists at the Institute can have continuous research without having to worry about private lands or state lands going through different changes. And so those kinds of cooperative things should be explored and need to be explored. And I guess my most passionate point to you would be, consider that our contiguous 48 states, and I've gone to school and worked on the mainland. So I love the seasons and all of that, and I miss the season. But if you look at the globe, the midriff of the globe, if you will, is our tropical zone. And besides our Puerto Rico territory and the state of Hawaii, there exists no tropical forest research areas.
In the United
Yet, the many of our countries around the world in the tropics lack the capability and the capacity that we in America have. Having national forests with a tropical emphasis would allow our scientists from America to work with people from underprivileged countries who we want as our friends. Instead of sending armies, let's send scientists. Let's help our friends rebuild and restore their forests for a healthy planet. And that's where I believe very strongly that a national forest in Hawaii, with being in a tropical area, provides a opportunity that we don't have right now. And we appreciate Congressman Case's effort on this because he grew up here. He's been in the rivers and the ocean and the mountains of Hawaii. He knows what it's like and he knows its limitations, but its potential. And we should all remember that our world has gone from a continental mentality, while we still live by continental value systems. Our globe is now an island. We are dependent all over the globe, and I think our country can provide leadership in tropical forest research in countries that don't have that capability. So
you make a very, very strong case. Madam Chair, I don't have a clock in front of me. Do I have any time left to do a follow-up question?
You are 2 minutes over, Mr. Lowenthal.
I thought I might be, but it was
I'm sorry. I talked too much.
No, you should never be sorry. It was fascinating. I yield back.
Thank you. Thank you so much. It was worth every second, Mr.
That's exactly right.
So the chair will recognize Mr. Tonko now for 5 minutes. Mr. Tonko? The chair will, and we will come back to Mr. Tonko if he gets back on. But right now, I will recognize Mr. Lujan for 5 minutes.
Thank you so much, Madam Chair. And Madam Chair, I have testimony from the New Mexico Acequia Association that speaks to the importance of this legislation. And I ask unanimous consent that letter be entered into the record.
Without objection.
Madam Chair, my legislation strengthens the consultation process between the federal government and the land grant communities. Mr. Archuleta, have you come across any specific actions taken by the federal government that have resulted in inadvertent adverse impacts to the land grant community?
Madam Chair, Congressman Lujan, yes, thank you for the question. Since we have such a long history and our communities actually predate the Forest Service, I can think of several examples where the United States action by a federal agency has impacted our land grant communities. I'll give you one prime example of some action that took place that affected two land grant communities specifically, the San Antonio de las Huertas land grant and the Cañón de Canuel land grant on the north and south end of the Sandia Mountains. In the 1930s, 40s, and 50s, the agency started to slowly claw back the community's ability to use that area for communal grazing. They were former common lands that weren't given to them during the adjudication process. By the 1950s, those allotments were completely closed, shut to the community. That forced many members of those communities to have to actually leave and migrate out to look for work. After that happened in the late 70s and early 80s, there was a movement to expand some of the wilderness. And even though the community still relied on some of those areas for cutting wood, or not expand, but create a wilderness, they've never really consulted with the community. And unfortunately, as a result, some of those uses that they still needed access to went away with the creation of the wilderness. And since the grazing was also already off the table, that, as well as being able to access fuel wood, is something that's gone forever for those communities. And so, we really feel that the consultation aspect is important because it can keep those types of actions from negatively impacting our community for generations. If we could just be at the table and ensure that our needs are recognized and that they're actually part of the management plan decisions to ensure that management is correct and that the things that happen, like wilderness, are in appropriate areas that aren't going to adversely impact or the ability to access those in a meaningful way. So that's one example where it's something that happened over time, but that it still has lasting impact for those communities.
I appreciate that, Mr. Archuleta, because you anticipated my next question, which was how would this legislation change that from happening again? And you clearly addressed that. I have two other questions I'm hoping to get to. Why is it so important to establish and formalize, or I should say formally recognize land grant boundaries?
Why that's important in this legislation, Madam Chair, Congressman Lujan, is that it actually lets the agencies as well as the communities know exactly where this legislation applies on the ground. Our former common lands are, they're vast areas, but they're not the entire breadth of U.S. Forest Service or BLM managed properties. So, there are areas that surround communities, and there's some that are critical and important, and it helps to be able to sort of identify those on a map. And we're not talking about the need to actually have an official survey, but something more along the lines of being able to identify them on official maps for management purposes, similar to how you see special management areas might be identified in a different color, or just clearly identified on Forest Service maps, for example, so that the agency as well as general public understand that that area has some type of a special designation, or that has something of interest that needs to be investigated whenever they're doing any kind of action in those areas.
And Mr. Archuleta, well, I know you're here representing the land grant communities. I think you can answer this from both the land grant perspective and the acequia perspective. Would a clear and collaborative process for land grant and acequia communities and the federal government, where fees are waived for historical traditional uses, make it easier to steward and maintain land grants and acequias?
Yes, the simple answer is yes, obviously. A lot of our communities are impoverished. I'll give you an example. The community of Trampas, which has acequias and it's a historic land grant community, entirely surrounded by the U.S. Forest Service. In 2017, in the American Community Survey, they had a median household income of $16,000. So they're a very poor community, and if we can actually cut back some of those fees that they have to pay, even the fees that are minimal, that's actually going to have a positive socioeconomic impact on those communities.
Appreciate that. With that, Madam Chair, thank you, and I yield back.
Thank you so much, Mr. Lujan. I will absolutely recognize any other members who come back on this call, but right now I would like to recognize myself for 5 minutes. And Mr. Archuleta, my questions are essentially for you. In your testimony, you mentioned some of the similarities between the difficulties faced by land grant communities in New Mexico and those faced by Pueblo and tribal communities in our state. As a member of Laguna Pueblo, I can personally attest to the difficulties New Mexico's tribal communities experience navigating the federal government and accessing resources that our communities depend on. Mr. Archuleta, can you briefly provide a little more perspective on how unique the connection is between traditional communities and the lands they manage? Why is it so important to you and other land grant heirs that these ties are maintained?
Thank you, Madam Chair. The connection that our communities have, just like as I mentioned in my testimony, our Native American cousins, we're land-based people. We have a deep spiritual as well as physical connection to the land. That's part of the fabric that makes up the culture of our communities. And so our ability to access those uses in the present. A lot of times we think of historical traditional uses as something that happened in the past. Like our Native American cousins, these are uses that are in the present for us. They continue to make up who we are culturally. And so having the proper ability to access those uses, it's important for us. And it's also a challenge, unlike our Native American tribes and pueblos here in New Mexico that do have federal consultation as an act that's required of the Forest Service or the BLM. We don't have anything similar to that. And so that's the challenge we always hit. That's the wall we hit with agencies. We've developed over the last several years a really good working relationship with federal agencies through the forest plan revision process, for example. And so, we've turned a page, I believe. But one of the things that's always come up is that there is no true authority for the Forest Service to have to actually recognize traditional uses for land grant and Merced communities and acequias. And there's no authority for them to, deal specifically with us on those issues apart from, the general public, or we're able to do cooperative agency agreements when it comes to special plans. But just general consultation is not something that they're required to do. And that's one of the things we hope to get out of this piece of legislation.
Thank you so much for articulating that. Mr. Archuleta, one area where tribal communities have felt the inequitable impact of land management under the Trump administration is near constant attacks on our sacred homelands. First, we saw the illegal destruction of the Bears Ears National Monument, an ancestral site for the Pueblo people. And now we're faced with the administration's efforts to open lands around Chaco Canyon to new gas and oil extraction. Our history and culture are under threats that they have not experienced in a generation. And I know this experience of threatened lands extends beyond our communities. Representative Lujan's proposal includes provisions addressing spiritual and cultural sites for land grant communities. Can you explain briefly for our people on this in this hearing why these protections are so important and what impact resource extraction or the threat of sale and disposal has on these sacred lands? I know that tribes also want land management plans to protect their sacred sites, but they have concerns about revealing the location of these sites to federal agencies. Do land grants have similar concerns? And if so, please expand on those.
Thank you, Madam Chair. When we talk about spiritual sites for our community, oftentimes we talk about sites that we are willing to identify. For example, we have several communities that have cemeteries. There was a discussion earlier about cemeteries and that issue of cemeteries that predate the Forest Service. We have similar cases where we have cemeteries that our communities cannot access. Their ancestors are buried there. They would like to actually be able to continue to use those cemeteries, be buried with their great grandparents. And unfortunately, a lot of those, they're not allowed to because of just where they sit. And the Forest Service isn't really interested in managing those at this time. So we definitely understand that. And while we respect and recognize that there's a lot of spiritual sites out there for Native American communities, and I think it's important for them to be able to protect where those sites are located and are protected in a manner that's going to benefit the community and their end user, but not interfere with how those sites are identified. We can definitely appreciate that, and we do have some sites out there that we may share in common, but at the end of the day, we recognize that our Native American brothers and sisters, they really have the opportunity to protect their sites in a way that makes sense and respects their culture and community. And our sites, if we are identified, we'd hope to have similar protections, particularly to allow us to utilize them and continue to have them be a part of our cultural being.
Yes, thank you so much. And I couldn't agree more. So thank you all so much for all of your testimony. Thank the members for their questions. The members of the committee may have some additional questions for the witnesses, and we will ask you to respond to these in writing. Under Committee Rule 3.0, members of the committee must submit witness questions within 3 business days following the hearing, and the hearing record will be open for 10 business days for the responses. If there is no further business, without objection, the subcommittee stands adjourned. And I thank you all again for participating.